Good evening, and welcome to Alternative Careers in the ADR, the next normal. On behalf of the Women's Lawyers Division, I welcome you to our program. In the absence of our chair, Sharon Bridges, and our chair-elect, Desiree Boykin, we encourage you to participate fully in this session. And also we encourage you to think about joining the Women Lawyers Division. The Women Lawyers Division is one of the most active divisions in the National Bar Association. We focus on professional development, community relations. We foster the pipeline of the next women attorneys through mentoring. And so we ask you to consider joining us. In addition, at the next annual NBA convention, we will be celebrating our 50th anniversary, and there will be a number of wonderful events planned by the division to acknowledge this great achievement of 50 years. So again, on behalf of Sharon Bridges and Desiree Boykin, the leaders of this division, we welcome you to this CLE. Thank you so much.
Thank you, Lisa. This is Dean Burrell. I am the chair of the National Bar Association Alternative Dispute Resolution Section, a co-sponsor of this program. Lisa is, of course, a member of our section. I just wanted to take a brief moment to say that if you are looking for a professional, a professional neutral, we encourage you to take a look at the NBA ADR section panels of certified arbitrators and mediators. Our goal is for folks to buy Black. For NBA attorneys and Black attorneys, when you're looking for a professional, think of us. I would also encourage you to take a look at our section. We encourage folks to stop through, attend a meeting, and if you're interested in becoming a professional, and you want to learn the cutting edge of what's going on in our field, take a look at us. And that having been said, I now turn it over to our second vice chair and my friend, Rebekah Ratliff.
Thank you, Mr. Chair, and thank you, Lisa. Good evening, everybody. Thank you for joining us. We're so excited to have you and to have this collaboration tonight. This is going to be a great conversation, so get a pen and paper out because you'll want to take some notes. First, I'm Rebekah Ratliff. I am the second vice chair of the ADR section for the NBA, and I am also a mediator and arbitrator with JAMS. My background is insurance. I'm actually a non-attorney mediator and arbitrator. I am a former commercial complex insurance claims professional, and I handled cases across the country in almost all 50 states and internationally, and now I'm an international ADR professional. So really, really proud to share information with you tonight. I would love for you to welcome our amazing panelists tonight. And first up for introductions is Erika Butler Bryant.
Good evening, everyone. I have been a licensed attorney for more than 20 years and have had my own law practice for more than 10. I have advocated cases before the American Arbitration Association and FINRA, and I have assisted my clients in mediating countless commercial, family law, and probate disputes. My career as an arbitrator with the American Arbitration Association was launched right here in the NBA, and I'm a proud member of the Women Lawyers Division as well as the ADR section. But I was trained as an arbitrator right here at the NBA at our 2009 San Diego convention. I currently serve on the commercial roster here in Michigan and elsewhere. And in that capacity, I hear and decide both commercial and consumer cases. I would like to thank Women Lawyers Division Chair Bridges and her board, our ADR section chair, Burrell, and his board, our moderator, and my co-conspirator in all things ADR section programming, Rebekah Ratliff, for your outstanding leadership in developing this program and giving me the opportunity to share. Thank you.
Thank you, Erika. Welcome. Tina Patterson, introduce yourself, please.
Thank you, and good evening, everyone. It's a wonderful opportunity to be here this evening, and I want to thank both the Women's Lawyer Division as well as the ADR section for this opportunity. I'm Tina Patterson. I am not an attorney. I am an ADR professional, so I cover the areas of mediation, arbitration, facilitation, and ombuds work. I have changed that label most recently to calling myself a conflict consultant because of the span of work that I cover. I have been in this space for 21 years. I was looking at some notes earlier today, and I've served on the FINRA roster since 2001 of October. So it's 20 years. I'm moving into my 21st year. I also serve on the panels of AAA, CPR, as well as I'm on the District of Columbia Bar's Attorney-Client Arbitration Board. I have completed my training with the Center for Effective Dispute Resolution, CEDAR. I'm an accredited mediator with them. My background is in information technology, intellectual property, and government contracting. Those times when a case may require someone with a security clearance, I do carry a security clearance, and that's part of my profile as well. As far as affiliations, I have been a member of the Chartered Institute of Arbitrators since 2004. I currently am the outgoing vice chair of programs with the North America branch. I'm a member of Arbitral Women. I have been a member of the International Association of Facilitators, the Mid-Atlantic Facilitators Network, and of course, as I mentioned earlier, I'm a member of the National Bar Association's ADR section. I'm currently completing my second year as a fellow with the American Bar Association section of dispute resolution. I look forward to the opportunity to share with you my experience and hopefully have a very interactive dialogue with you. And with that, Rebekah, I'll pass back to you.
Thank you and welcome, Tina. And it has come to my attention that Chair-elect Desiree Boykin has joined us, and we would love for her to bring greetings before we continue with the panel.
Thank you so much, Rebekah. Desiree Boykin, I am the chair-elect of the Women Lawyers Division. Sharon asked me, our chair asked me to be on the call, and I am more than happy to do so. I am in-house counsel. I work for a national nonprofit. I've been doing so for almost 20 years, and I'm really looking forward to the conversation today because I feel like in getting here, I had a lot of alternate careers. So definitely looking forward to the conversation, and thank you for having me.
Oh, I actually was on mute still, wasn't I? Just talking away. Lisa Love, please introduce yourself. Lisa is our third panelist. Thank you.
Good evening. Again, my name is Lisa Love, and I am a fairly recent ADR professional. I have spent over 30 years practicing law in the areas of commercial transactions, infrastructure, finance, and investments. I currently am a member of the AAA on various panels, including the complex commercial and the M&A panel. And I also am a fellow with the Chartered Institute of Arbitrators. In addition to that, I do some FINRA cases, as well as some CPR cases. So I look forward to sharing my journey with you and hope that something that I may have to offer would be helpful to you.
Thank you so much, Lisa, and welcome. So ladies, let's jump into this panel. We know that historically, alternative dispute resolution did not originate as part of the legal profession. It started in towns where the elder who was respected by everybody was called in to help people barter with their cows and chickens and pigs. So it has certainly evolved. And in the last 30 years or so, ADR has become more widely embraced as an alternative to trial. So let's first explain the difference between mediation and arbitration. The differences, some might say, are subtle, but very important. And Erika, I know you're going to explain the difference.
Thank you very much, Rebekah. Arbitration and mediation are both forms of alternative dispute resolution. What they have in common is that parties have a high degree of control over the process. Where they differ is in outcome. In mediation, the outcome is entirely up to the parties. The mediator's role in that process is to help guide, but not decide. Arbitrators, on the other hand, determine the outcome of the dispute. An arbitrator's award is legally binding and enforceable until or unless it is either vacated or modified. While a mediator does not have the power to decide a dispute, she does have the ability to influence and help facilitate resolution through either her subject matter expertise, process expertise, and often a combination of the two.
That's awesome. And one of the things I'd like to bring out too about mediation is that mediation is self-determining. Mediation is considered to be more collaborative as a process, and it is less formal than arbitration. Arbitration, of course, is less formal than trial. But in mediation, there is only a settlement if the parties agree to it. A mediator is a facilitator. And Erika put it best, they guide, not decide. It's a process where parties have taken into their own hands the opportunity to decide the outcome. So those are important distinctions to make, both confidential processes and really growing attraction for access to justice, because as we consider the opportunities for diverse neutrals to be chosen, selected for these cases, there's more chance to enable equitable outcomes, because the mediators need to look like the people who we see in these hearings. And so how did you become a mediator arbitrator, Tina? Yep. There you go.
Thank you. Yes, I've unmuted. My journey as a mediator arbitrator actually began, I was preparing to become a Foreign Service officer with the U.S. State Department. And I happened to see an ad regarding an alternative dispute resolution program offered by Southern Methodist University. And I thought that that skill set would make me a very competitive Foreign Service officer. Nevertheless, after taking the exam and successfully completing one part of it, I didn't complete another, and there was a change in administration. By that time, my instructors had approached me and asked me about being a mediator and about being an arbitrator. And it was my arbitration instructor that was mostly concerned about me being in the space. And what he told me at that time, and I had been in corporate America for about 15 years at that point, his numbers were not surprising to me. He said, you're under 40, and I'm suggesting to you that you become an arbitrator because you get it. You understand the process, and I think you can manage the process. What I need to tell you is that the average arbitrator is over 65 and a white male. And I just smiled, and he looked at me and he said, "Why are you smiling?" I said, "I work in corporate America. Who do you think I'm working with?" And that began the journey. I was initially working court-appointed cases for mediation, branched out on my own, and with the arbitration piece, it was actually my arbitration instructor who wrote my first letter of recommendation for me. At that time, it was the National Association of Securities Dealers that I sat for my exam, passed, and then went back and got chairperson training. So that's how I got started.
Awesome, wonderful. And Erika, how did you get started?
Well, as I mentioned in my introduction, I was trained at the NBA 2009 convention in San Diego. But I attribute a huge amount of credit to women on my path to becoming an arbitrator. Back, a long, long time ago, when I was a brand new baby lawyer, I joined one of our local affinity bars, the D. Augusta Straker Bar Association. And at that time, there were 2 women on the board, Angelique Strong and Danan Goodrum. And they welcomed me into the organization, and they helped develop me as a leader, so much so that a few years later, I was noticed by Janice Holdinsky, who is with the American Arbitration Association. At the time, she was the vice president of the commercial division in my area. She's now a vice president in labor and employment. And so she approached me and asked if I was interested in becoming an arbitrator, that AAA was committed to diversity and inclusion within its ranks. I told her at the time I was only a few years out, and I knew I had to have at least 10 years of practice under my belt before I could even apply. So I continued working and serving in our affinity bar associations, including the NBA. And around that same time, when I became eligible to apply at the 10-year mark, I had also become active in the ADR section under the very capable and passionate leadership of Gloria Johnson. And so it was really just a confluence of positive factors that led to my application being submitted to AAA, AAA selecting me to serve as an arbitrator, and my being able to have my training not in Chicago with a bunch of people that I didn't know, but in San Diego with my fellow MBAers. But I don't want you to think that men had absolutely nothing at all to do with the process, because I also want to give fair credit to Harold Coleman of the AAA, who was my trainer and has always supported and encouraged my development as an ADR professional. But I would be out of line if I did not say thank you to the Black women lawyers who helped me get where I am today.
Oh, that's awesome. Thank you, Erika. Lisa, how did you become a mediator arbitrator?
So it's interesting that all our paths were very different. Some of us are attorneys, some of us are not. I was a member of the Leadership Council on Legal Diversity. It is an organization that is still established, still around, and very active to promote diversity throughout the legal profession. One of the programs, one of the initiatives that they had was a fellowship that was a joint project between FINRA and CPR, CPR being the International Institute for Conflict Prevention and Resolution. So as a result of that, I was a new fellow. They have a fellowship program at LCLD. And as a result of that, they offered all the fellows the opportunity to participate in the FINRA CPR fellowship, which I did. Interestingly enough, back then, not many people took up the opportunity. And I think that for me, one thing that I've always tried to do is try to be open. And, you know, if there was an opportunity, try to take advantage of it, not necessarily always knowing where it would go. So I participated in that program. And as a result of participating in that program, I, was listed on FINRA, listed on CPR. I continued to make inroads into the ADR profession, got introduced to AAA. And sort of the rest is sort of like history at this point in time. And, I am not a litigator. And for attorneys, oftentimes in the ADR space, being a non-litigator is a little different. So I encourage you, if you're not a litigator, don't worry about it. There's still a space at the table for you.
I love that. I love that you said that. We know that ADR touches everything. And of course, I mentioned that my background is insurance claims, and insurance touches everything. Every single industry across the world, nothing moves without insurance. And so I had a mentor who said to me, You are living beneath your skill sets. You're doing great work as an adjuster, because I handled cases across subject matters from medical malpractice to municipal liability, commercial premises, products, construction defects, auto and trucking, you name it. And he said, you've seen everything and you need to be a mediator and consultant. And so when I walked away from corporate America after 25 years, I started my own mediation, arbitration, and consulting firm. And I've changed brands twice. I was the first Black female non-lawyer ever to join Henning here in Atlanta. And now the first Black female non-lawyer ever to join JAMS. And I'm very excited about that, because JAMS is invitation only. And my subject matter expertise from the insurance industry is a debt that I'm still repaying. I feel like it's a debt that I owe, because it equipped me to handle different types of matters. And this field, again, touches absolutely everything. And there are so many opportunities, especially with COVID and the overlapping pandemics that we've been dealing with. So many things are surfacing now that we didn't even know would be an issue. So, Tina, what are some of the opportunities that you see in ADR for lawyers and non-lawyers? Of course, you and I are non-lawyers.
Certainly. And I'm glad you mentioned that, Rebekah, but what I'm going to talk about really crosses, because when we talk about ADR, we're really talking about subject matter expertise, whether your subject matter expertise, as you indicated, is in the space of insurance, or it's your past experience, and what you're bringing to the table. So when I think about some of the opportunities, think in terms of how do you help parties resolve their disputes? How do you help parties feel that they have an opportunity to have their say? And I'm talking about mediation at this point. And when we think about opportunities, think in terms of training, think about how you set yourself apart. Do you want me to talk about specific programs, or go back a little bit and talk about the history and how we got to today?
Talk about the history, because we are going to get into the programs.
Okay, so earlier programs, and I'll talk specifically about Access ADR, which was really a program that was born by Marvin Johnson and Homer LaRue, and the focus was primarily on mediation. And the idea was to give opportunity to individuals who had experience or who were interested in building their career, their I'll call it their scope of work, to include mediation. And this program included meeting organizations, talking with organizations, presenting these individuals, and saying, these are individuals who have experience, these are people who have undergone training, who can mediate cases. The challenge continues to be, and again, I'm not talking about whether you're a lawyer or not a lawyer, is being selected. Actually having those parties say, you know what, we're comfortable with having Lisa or Erika or Rebekah serve as our mediator, or we're comfortable with Lisa and Erika being the chair and the wing on our arbitration panel. This continues to be a dialogue, to the point of, we see CPR, AAA, and other organizations saying, what can we do to increase the diversity? And they're taking diversity on a much bigger scale and saying, we need public arbitrators. You don't have to be an attorney. What's your area of subject matter expertise? We will train you in the process, but can you manage the case? We want individuals who have a breadth and depth of experience. So where we might have seen 10, 15 years ago, primarily litigators who were burnt out and said, I need to do something different, or retired judges saying, you know, I want to do something that I think is going to be a little bit more easygoing, to seeing school teachers, seeing individuals who may have worked in a non-legal space coming into the space because they, one, are aware of, as you heard Erika indicate earlier, holding that space for the parties. Now, of course, arbitration is going to be a little bit different, but we're also seeing this discussion take place in both the domestic and international spaces, where we're seeing individuals, organizations, and I'm thinking about the Chartered Institute of Arbitrators, as well as some of the other managing organizations saying, you know, it's great that we've brought on these retired judges, but we need to have individuals who understand not only how to run the process, but how to use the technology. how to use the technology in a way where the chair isn't comfortable with using Zoom or GoToMeeting, and engaging the parties so that we can resolve the dispute and thinking in innovative ways. I think with COVID, the integration of technology has been both a blessing and a challenge. I think all of us have been required to undergo training where we've had to understand when, if we need to be, if we're going to be independent and use ad hoc arbitration, that we need to consider having a virtual private network so that we're not Zoom bombed or our session is not infiltrated by parties who aren't invited. But it also makes us think about what is the capacity of these tools and applications to help us serve parties, and what are the limitations. I know I've sat in on trainings where people have had to turn off their cameras because the software application, the online meeting system just did not make it possible for that person to continue to engage. I'm going to pause there because I know I've said a lot.
Oh, that's all good information, because you set it up for our discussion based on our prep. We were talking, of course, about opportunities coming available and also initiatives. So we can just interchangeably talk about those things. And I do want to also say, one of the things when we talk about opportunities, we can talk about opportunities for work, and we can also talk about opportunities for training. Erika hit the nail on the head. The ADR section of the National Bar Association is a proving ground and a great way to come in and get annual training, consistent training. The ADR section nurtured me when I was on my own, and still nurtures me, which is why I love to give back. So when I talk about debts that I owe, I also owe a debt to the ADR section for providing opportunities for me through training, but also that's how I got on the FINRA panel of mediation and arbitration. I'm a FINRA arbitrator, but for CPR, I'm on the commercial insurance panels of distinguished neutrals for mediation and arbitration. So that undergirding, that training, the support that we got under the leadership of Gloria Johnson has just been amazing, and we continue to build on that. So if you would, Lisa, talk a little bit. There's a question in the chat, and any of us, by the way, I will answer your questions if you put them in the chat. We'll just incorporate them into our talk. But Lisa, what are some opportunities? And feel free to talk about initiatives as well, because one of the things we said in our prep was we are not window dressing. Not only do we want to be on these lists, but we want, we need to be selected, and the world deserves for us to be selected. Lisa?
Sure. So just responding to one of the comments in the chat, I guess the question was, someone is getting a certification from their law school when they graduate, and will that be sufficient for purposes of working in the industry? And I think, and I guess we will all have different responses to that question. I think the certification is a good start. I think each panel has their own requirements. And so you will have to satisfy the panel requirements for the particular panel you're trying to get in on. So AAA, with the certification from law school, they may allow you on a consumer panel. They may wait for you to gain more experience to let you on the complex commercial panels. And then also a lot of these panels also have their individual training that you have to go through before you're allowed to be on the panel. So I think, to put it succinctly, I think that's a good start. I think you're probably going to have to put a little bit more to it to get on the panels and get the type of work that you need or want. In terms, oh, go ahead.
So I just wanted to, I'm sorry to jump in, Lisa.
No problem.
But one of the things I wanted to add to the question in the chat is that it also depends upon your jurisdiction. Because in Michigan, for example, the Institute of Continuing Legal Education offered a 40-hour training that is mandatory if one wants to serve or be listed on any of our court rosters. But because ADR is inclusive in the sense that one does not have to have a law degree in order to become a mediator, and in some cases even an arbitrator, When I went through my 40-hour mediation training, which I use more as an advocate than a mediator, which is why you didn't hear me talk about it much. But there were law school students in my cohort. So it depends upon the jurisdiction, and I would encourage you to talk with your law school more about your question. States ADR certification. So I don't know if it's mediator training or arbitrator training, or if it's both. But to see, what jurisdictions you would be able to practice in with that training. And once you get that training, while you may not be able to earn money at it right away, you could at the very least find a mentor or sponsor who may be willing to allow you to sit with them so that you can get some additional learning and pick up tools and tricks that you can add to your own toolkit, so that when you get your own cases, you'll be ready to rock and roll. So that's what I would have to offer.
That's great advice. Thank you. And Lisa, I know you and Erika are both going to talk a little bit about initiatives and opportunities.
Yeah, but I know Lisa has something more she wanted to
Back
say,
to you,
so
Lisa.
Oh, and Tina had her hand up, so I don't know.
Oh, did you want to speak to the question?
I'll let Lisa answer and then I'll follow up, but thank you.
So in terms of opportunities in the ADR space, I think there are a lot of opportunities that have opened up. I think, there are some ABA initiatives, but also one of the things that gave a lot of publicity and press to ADR professionals is the Jay-Z case that people probably may or may not be aware of. But Jay-Z was in a litigation, and it went to arbitration. And there weren't enough, in his opinion, there weren't enough diverse people for him to select. So his attorneys made some moves and sort of got the arbitration at least stayed. I didn't follow the case to what it actually ended up, but AAA had to file a lot of papers in which they had to defend their diversity training. They had to list they didn't have to, but they listed all of their diverse arbitrators. I was happy to see my name listed in that litigation. But in addition to just being open opportunities, I think someone and a couple of us have already spoke about, it's really critical that you find your space. Like, what is your expertise? And then you can create the opportunity in that area. So for instance, for me, I have no experience in family law. I have no experience in personal injury. So those type of cases I would not get and probably would not want. Because one of the things about being an arbitrator or a mediator is that you bring to the table your expertise, and your expertise is acknowledged and recognized and is helpful to the case. Unlike sometimes, not all the times, but sometimes when you go to court, your judge may or may not have the particular expertise in the area that you are that is similar to your case. For instance, in New Jersey, there's a rotation. So the judge may be in family one session, and then they may be in some complex commercial the next. And so they may not always have the expertise, but I think as long as you have an area that is discrete and that you are excellent in, there should be opportunities, given all the opportunities there are for ADR professionals now in the field.
Yeah, those are great points. Thank you. And Erika? And then I'm gonna get back to you, Tina, on the question.
Well, Lisa pretty well covered it. I have nothing to add. She hit all the points. So
She did. Yeah. Awesome. Okay. Well, Tina, what did you have to offer to the question from the chat?
So regarding the question from the chat, and I think Erika touched upon this, but I wanted to pull the thread a little bit further because I think this is important. And it's the idea of a mentor. And we'll talk some more about this during the open part of Q&A session, but I wanted to talk to level set this now. It's imperative to think about what your expertise is, and don't think that you can't ask someone to shadow them. I shadowed someone as an arbitrator. I see that the young lady has specified what her certificate is in. One of the questions that should arise from that is, are you interested in domestic dispute resolution, or are you interested in international dispute resolution? And the path is slightly different if it's international. And the time to start thinking about that is now. But that also entails the shadowing, the mentoring. I also wanted to pull the thread a little bit more on the window dressing, because I know it's something that has been of concern and we haven't talked about it. And as part of the Jay-Z discussion and other case management organizations, they've been very concerned about what does diversity in ADR look like? And is that just sheer numbers? Is that taking that number and pulling it apart a little bit further in terms of male, female, people of color? And I know that initiatives such as the Ray Corollary Initiative are working to say to administrating organizations, look, when you present panel members or prospective panel members, ask about diversity. And diversity is not just Black, white, it is male, gender, sexual orientation, but also ability. And I know that this is something that, whether it's CPR, AAA, FINRA, surveys are run, data is presented, and I'm going to put in the chat a couple of reports that have been floating around in the past year, 2 years regarding diversity in ADR, but it's something that we strongly, and I think I can speak for all of us as panel members, as well as Rebekah, it's something that's near and dear to us because we see it when we come into a room as an arbitrator or as a mediator. I can tell you in my 20 years as an arbitrator, I don't think I've ever been on a panel where everyone has been African-American. And not that that makes a difference, but when I walk into the room, sometimes I'm the only person of color in the room and I'm Madam Chair.
I'm looking forward to seeing that all women, all
Yes.
African-American panel.
Okay.
I'm really looking forward to
I
that.
feel like what Ruth Bader Ginsburg said when they said, well, how many women is enough? And she said 9 on the on the Supreme Court. Yeah, when there are 9, that'll be enough. So yeah.
So I just wanted to bring those points up, and we can of course talk about that more during the Q&A period. I'm going to paste into the chat the articles that I was mentioning regarding diversity in ADR because it is a point of contention. The case administering organizations see that they're doing their best, and opponents will say, you know, you can do more. 30% is not enough. It should be 50%. And then when we start to peel apart those numbers, when we start looking at the number of African-American women serving as ADR providers, the numbers start to dwindle. And Lisa, I'm glad you were on the list. I know the Jay-Z case has been talked about a lot, but that should not be an anomaly. That should be something that's happening on an ongoing basis where we see some fair representation. And again, to the credit of these organizations, they're trying, but there's still more to be done.
Yeah, so I want to mention some of the efforts and initiatives. AAA, of course, has the Higginbotham program. JAMS has a new fellows program that is being piloted and coming out. CPR has the Pathways program, and FINRA is looking for, of course, that's the Financial Regulatory Authority. FINRA is taking applications as well. I know several people recently who have joined the FINRA panel of arbitrators. And these panels are important, but when Tina mentions the Ray Corollary Initiative, the research was done around the Ray Corollary. It attaches to Resolution 105, ABA Resolution 105, to increase, which is an initiative to encourage and increase the selection of diverse neutrals. The Ray Corollary has that 30% measurement. And the reason is that the research has shown that that's critical math. That 30% is the percent. If you have 3 out of 10 on a strike list, the chances are higher that a diverse neutral will be chosen. And so that's where that 30% metric comes from. But what are some tips as we are, we're mentioning organizations, we're mentioning lists, of course, the National Bar Association has an ADR section with training that is continuous. What are tips for people who are looking to transition into the practice of ADR? And of course, Lisa, I know you touched on that when we were addressing the question in the chat, but I will say, if you, to kind of piggyback on what Erika said, in your state, find out if, if there's required training for licensure in your state. Some states call it certification, in some states it's a license, in other states it's called a registration, but in Georgia, it is a 40 hour class that you would take in order to qualify for court-connected mediations. There's so many opportunities out there, even in government. There are some sectors that actually will outsource mediation and arbitration. So you might consider getting an MBE, WBE. I'm a minority business enterprise and woman business enterprise, which opens up more doors. But what are some tips, some additional tips for transitioning into the practice of ADR? Lisa, anything else to add to your points you made?
From a practical perspective, and I know that a lot of people take a track where they do a lot of the court mediations and arbitrations. One of my issues has been a lot of those programs are low pay or no pay. And so, whether or not your path permits you to do that is a concern. For me, I was not willing to commit free time to learn the business of ADR because I had a full-time practice, and not, if I'm gonna make money, I'm gonna try to get cases where I'm gonna get paid. So as you look at things, you have to sort of figure out where you are in your path. Maybe it's good for you to take some free cases, and you might get into a groove of the ADR groove a little faster. But there are opportunities if you decide that you really want to get paid for this and can't do the freebies. And so I encourage you to look for those type of opportunities, as well as opportunities to do things free if it fits into your business plan.
I love that, Lisa. It's important to say that because, to be honest, I actually did do a couple of freebies, but I'm a non-lawyer, and those programs do not pay much or anything, like you said, in some situations, because now, of course, it's becoming popular for communities to have arbitration centers. But it is great practice for experience in ADR if you need that. If you want to get comfortable, that's what you may want to use it for. But Lisa is absolutely right. You have to determine what your goals are, what your path is, and do what's necessary to get what you need as you build.
Well, let me just, I'm sorry. Go ahead. Let me just add this. What I would do free, and I did a lot and still do, is I participate in moot arbitrations. Because there could be global moot arbitrations. And so you'll get an information package that might be 100, 150, 200 pages long. You have to go through it. But it gave me the sophistication of the type of transactions that I was accustomed to. And therefore, I was willing to roll up my sleeves and do that free. So I participate in foreign direct investment moots, which deal with investor state type of issues. I will deal with Vismoot, which is a huge global moot arbitration that puts out a package every year, and law schools all over the world participate. ICC, I participated in its mediation conference and worked on the package, or sometimes just reviewed the package or just sat in, but it was a great learning experience because it allows you to participate as if you you are a chair or as if you are on the panel. And the same kind of expectations, because you don't want to shortchange students who have rolled up their sleeves and done a lot of work. So again, if that could be another way, especially if you're interested in more sophisticated transactions that you might get if you were just coming out the box and doing like a consumer thing where you might get something like a Verizon dispute. You know, it could be as small as that in some of the commercial stuff.
Yeah, those are all great points. Thank you. And Erika, what are some tips for transitioning?
Well, the biggest tip that I would share is to really do your research and as it says in the word, count the cost. You know, before you do it and have a plan. In my jurisdiction, when someone becomes a mediator, for example, and ends up on the court roster, there was the 40-hour training, and then one has to do a practice mediation in one of the community dispute resolution centers for which one is not paid. But once one goes on a court list, judges are required to assign cases from that list based upon party selection, and those mediators charge what they charge. But I'm also aware with some of the panels we've been talking about, one of the barriers to entry is experience. And so part of the decision calculus for a person transitioning into ADR is to figure out strategically which panels she wants to get on and what is required to get there, and to have a strategy. And one of the things that will help with that is to talk to other ADR professionals about their journey, and if there's a particular panel that you're interested in, find out and give us the opportunity to pay it forward, by helping you get there. So that would be the biggest tip that I would add to what Lisa already said.
I love that. Thank you. And Tina, any tips for transitioning into the practice? And then you can talk, we'll go ahead and spill over into marketing, how you market your practice.
I think Lisa and Erika have covered a great deal. I want to underscore this point. And I have shared this with people, there's a common perception that I've completed 40 hours of mediation training. Now I'm going to hang my shingle and people are going to run to me. That is not going to happen, unfortunately. The reality is you will have to spend some time getting, and I'm going to call it the 3 E's: experience, exposure, and expertise. So whether it is community mediation, whether it is commercial, whether you want to do family law or juvenile offender or other degrees of mediation, you've got to spend some time. But I tell people, don't get caught in the, I have to do it for free. Whether we're talking about ADR or we're talking about buying a pair of shoes or buying another commodity. If it's too inexpensive, people begin to wonder, is it worth it? So know your rate, know what you should be charging, know what your market will allow. And I know we're going to talk about this in marketing, but think about this in terms of how do you increase your exposure? How do you increase your exposure in a way that you become known as a subject matter expert? Rebekah, you're a subject matter expert as it relates to insurance. And we need to think about that. My background is in information technology. Lisa's background, as she mentioned, M&A and larger commercial transactional efforts. Know how you want to bring that expertise. Can you compare? Can you compete with someone who's been in the space for 35 years? Maybe not, but you might know the newest trends. You might understand the latest in terms of rules, regulations, upcoming rules and regulations, and how you can apply that. And I said this earlier, technology is also becoming a differentiator. How comfortable you are or are not with technology is going to set you apart. So those would be my tips. I think Erika really said something that really has been beneficial. Ask people, talk to people, pull them to the side and say, how did you get started? I'm happy to pay it forward, but I also want to make sure that I'm honest with you. I was in a graduate certificate program when I first got in this space, and some of my classmates went out and hung their shingle as soon as they finished their 40 hours of training and were very disappointed and were very unhappy. And I tell people this now, have a backup. We all know, and none of us have said this, mediations get postponed, arbitrations schedule, people end up settling, and that money that you thought was in the bank isn't in the bank anymore. And you need to have a backup plan, whether that backup plan is, your trust fund, or like me, my company has multiple areas in which we work. So if that arbitration shouldn't move forward, I have a backup. And at least
Did
I
you
see
say
you got
trust
your hand
fund?
raised. Yes, I did. That is not me, but some people might have a trust fund, and you know
I
what? I'm
love
not
it.
mad at you. But
Yeah,
what I am saying is you've got obligations, whether that's your law school debt, a mortgage, or any other obligation. That is your priority. So Lisa nailed it when she said, you can't do free. And I believe in paying my debts, but I can't do free forever because obligations require me to do otherwise. So I'll stop. I saw your hand raised, Lisa.
And I want to be clear. Oh, I'm sorry, Lisa. I didn't see your hand up. Go ahead.
I'm sorry, just a little point. One, we talked about mentors, and that's been very important. But one of my mentors told me, like one of the first meetings I had with him, was that you have to have a 5-year plan at least. So you're not gonna, if you want to do ADR and possibly do it on a full-time basis, you have to project about 5 years. And so in that 5 years, you need to plan your plan and work your plan. And again, it's not an instantaneous thing. It's something that you really have to work at. You have to work at it by networking. You have to work at it by speaking. You have to work at it by writing. And a lot of these things, quite frankly, come natural for some people and are not so natural for others. And so you have to find what your sweet spot is. And what I always say is be eternally optimistic. If it's something that you really want, you just have to keep going after it. You may get a lot of no's, but each no gets you closer to that yes. So have that 5-year plan, take the no's, take the hit of the no's, and keep the optimism eternally, and just keep it moving, because you will make it. But it is a road, a path, and it's not a short-term path. It's actually sort of a mid-range path. 5 years is a decent amount of time.
Yes, that's right. Yeah. Erika,
And
this
I
is
just wanted to
really
say-
important information.
It is. And I want to say, for those of us who are practicing, and I want to be very transparent, I am not a full-time ADR professional yet. Mostly because I still really love practicing law. And that keeps me very, very busy. So for those of us who have practices, like we're saying, don't go get the training and think, okay, now I'm going to pivot and just do this full time, unless you have, built up the resources to be able to do so. But as a sole practitioner who likes having lights, water, and food, I do not put all of my eggs in a single basket. But certainly over time, one can make a very, very lucrative living as an ADR professional full time. Just don't set your expectations on it happening right away.
When you mention eggs in the basket, I'm thinking I like my eggs scrambled with cheese, and cheese costs a little extra. So yeah, that's exactly right. You have to know that it does take a while to build a practice. And Lisa, that's a good, that 5 year, I can tell you that that's accurate, at least 5. And so, it's important. So let's talk just a little bit about the distinction between a mentor and a sponsor as we round off and get ready to give you some other advice. Lisa touched base on some really important advice. Speaking, if you are a speaker, get on the speaking circuit. Publishing, serve in a trade association like the National Bar Association, American Bar. I will also mention LinkedIn. I will not connect with people if they don't have a picture on LinkedIn, a professional headshot. And just your standard, you have to make a standard, and you have to build your brand, and your brand starts much earlier than where we are now. But that personal and professional branding are interconnected. And so as you use LinkedIn, you can leverage LinkedIn in a lot of great ways to build and increase and expand your network. So I wanted to make sure I mentioned LinkedIn. Mentors and sponsors. A mentor is a person who knows you and rides alongside you and will tell you the truth about you. A sponsor might or might not know you as well, but they know your work and they're willing to lend their relationship capital to you, but you have to be worthy of it. And so a person who will speak on your behalf when you're not in the room, you have to be worthy of that because somebody's putting their name behind you. And then for both mentor and sponsor, you need to know what that person might need from you and be ready to do it. Lead with a yes if you're ever asked or if the opportunity ever presents itself. So ladies, what advice, colleagues, would you give to a person who is considering a career in ADR? Maybe 30 seconds. What advice would you give? 30, 45 seconds. What's your nugget? Oh,
I already said mine, so I'll say it again. Plan your plan and be eternally optimistic, not only with ADR, but whatever else you're trying to achieve. Just keep on working it, and it will come to pass.
That's right. That's right. Thank you for that. Erika?
Well, to quote a famous footwear slogan, if you want to, just do it.
Huh? I like that. Okay. Yep. Boom. And Tina, what's your nugget?
Say yes to opportunity. And when necessary, lean in for support, encouragement, and challenges, or to be challenged from mentors, your support system, and if necessary, your sponsor.
Awesome. Well, I love that. And here's my nugget. No one does it alone, and there's enough for everybody. So let's stick together and pay it forward. We are rounding out. I want to see if there are any additional questions in the chat. In the meantime, okay, so for those of you who may not see it, the program will be posted on the NBA website on the webinars page within 24 hours. And right now, I'd like to just take the opportunity to thank Madam Chair Bridges, Sharon Bridges, and also the chair, who is obviously the chair of WLD, Women Lawyers Division of the National Bar Association, and also the chair of the ADR section of the National Bar Association, Mr. Dean Burrell. I'd love to thank my sisters who joined me on this journey. This was a great conversation. I hope that our viewers were enriched by it, and certainly connect with us on LinkedIn. Look, just keep us posted on your journey if you wish, and we would love to help you. And to all of you, we're in November already, and Christmas is tomorrow. So in the middle of this pandemic, may God bless you and keep you and your family safe during this holiday season. Desiree, did you want to close us out?
Thank you for that. This was such an enriching conversation. I know I learned a lot, and I hope everyone that was able to join the webinar owned a lot. And if you weren't able to join, or someone who wasn't able to join, please let them know that they can find the recording, where they can find the recording, so that they can also benefit from this conversation. So thank you to all the panelists. Thank you for those nuggets of wisdom at the end. They really resonated with me. And thank everyone for attending the webinar.